as per I think previous discussion, what we're going to do is hear from the Prosecuting Attorney's Council on House Bill 722. We're then going to shift over at 10 o'clock or so into House Bill 941. And then we're going to have a hard stop at noon, because we've had people who have traveled, including the gentleman to my right, who I promised to get home by 5. But I do not control the traffic in Henry County. But you got to have construction in order to free up the flow. I tried to say that at a forum before the holidays, and it didn't go well. So, Mr. Spinhouse, I'm sorry, if you wanted to come on. There is a sign-up sheet for anyone who wants to be heard on House Bill 941, and it is, let's put it over, yeah, if we could just put it on the podium, I guess, over there, so that anybody who wants to sign up on 941 can. And I've got certain folks I know are going to testify in 941, including the Sheriff's Association, the GBI, the FOP, and the prosecutors will be in the initial panel, and then we'll just go from there. But we will have a hard stop at noon. So again, members of the committee, I tasked Mr. Spahas to address 722 and any concerns. We heard from the sheriffs at the last hearing on 722, Sheriff's Association, excuse me, and we'll hear from the prosecutors here. Mr. Spahas will, I'm sure, be as expedited as he can while being thorough, and then allow for some Q&A. And we may take 5 after that, since Mr. Spahas will be on the next panel, and he may need 5. So I'll turn it over to you, Mr. Spahas, when you're ready.
Thank you, Mr. Chairman. Also, I have with me Ashley Wright, the District Attorney in Augusta. She's up here today on behalf of the DA's Association. So let me start out by saying we were strongly involved in the what I'll consider to be the good work product that come out of HB1 earlier in this session. I want to thank Representative Peake and the members of this committee and others that helped us negotiate what I believe that had been a good and fair bill that accomplished a huge stride forward in what we were trying to do with children with disorders that we all believe can be helped by the oral substance that we approve. What I'm here today to do is talk about HB 722 and talk about some of the significant changes between that and the bill that ultimately passed and was signed by the governor just months ago. Let me say this too: the prosecutors in the District Attorneys Association are very supportive of the concept that there is a substance out there that has some medical value to a certain population that apparently no other substance can help. We're sympathetic to that, but we're also officers of the law, officers of the court, and have got to acknowledge the fact that until something changes at the federal level, marijuana and marijuana-related products like we're going to discuss are still a Schedule I substance or controlled by federal law as well as state law. So I have to remind everybody, no matter what we do here or what the General Assembly ultimately does, it's going to be in defiance of federal law. So the question becomes what level of comfort or repealed and reserved and effective July 1st of 2017. That's in 4 places in this bill, and ultimately what that does is eliminate these provisions. However, it does maintain some concept of low THC oil in the study, and I want to touch base on those. Now remember this, the research program was originally designed to be clinical in nature and allow these children to have access to it in a controlled environment where we could study them, see the reaction they were having to the substance, and make some findings related to that. The first point I want to show you on that is line 57 or so, is the removal of clinical. I haven't heard a good explanation for that, but I did do some research into that. And what that means is these research programs would now be broad enough that they no longer require any kind of observation of the patient or whether or not the treatment is working. It's just, as long as it is research-based and in nature, it would be broad. And remember, this thing is not just for the university system, because there's the language that's in the bill that says, or any authorized clinical trial or research study protocol. So we believe that's a very broad, at some point in the future, there could be some broadening of that. The second one I want to point out is the striking or the inserting of manufacture, distribute, dispense, sell, or possess with intent. In the previous HB version, the research program and the people involved in it had some very narrow definitions of being able to possess it and use it in the study. This has been broadened for some reason or another to include manufacturing, distributing, dispensing, selling, or possessing with intent. Also, I would point out that this removes from the research program any controls over the level of THC or the amount of THC oil. By striking that, now the researchers or the people working for the research program can possess any amount of the low THC oil. The other thing that I noticed that it does is it strikes the designated employee, and still requires an employee of the research program to be designated by the research program, but they no longer have to be involved in the research. So apparently you could have a person that does just the distribution that's not involved in that. And I'm sure there's a reason for that, but we're not certain about that. The reason I point these out is the broadening of this research program clearly looks to be a mechanism, if not the primary mechanism in this, to allow for a greater possession of and distribution of the substance. Again, maybe when the author goes through it, I can get a better feel or understanding of what that's about. I'll go on and start to section 5 because that's the, after dealing with what we've discussed, this is the real crutch of the new portions of the bill. There's some very broad definitions where they define medical cannabis, marijuana, and cannabis device. Now, one of the comments I was going to make was that the cannabis device and the existing drug-related objects at 161332 were in clash. This does attempt to narrow that. The sub narrows it to what I believe that is intended to just mean gel coat or gel caps at this point. So that is an improvement in the bill in that what we're apparently looking for is a description of the delivery system. So at least now I understand that. But I also point out that we've got several other definitions in code that are still in contrast with the new definitions that are created here. We've got to deal with 1613.25, which defines THC, that contains a lot of the same elements that are described here in marijuana. We've got marijuana flavored products at 1613.30.6. We've got the existing definition of marijuana at 1613.21. And then, of course, I just pointed out about the drug-related products at 1613.32. But now let's concentrate on what this marijuana means. The new marijuana definition in 1612.200 apparently, when read in conjunction with the medical cannabis, is supposed to mean marijuana in any substance other than a green leafy material. And I'm going to address that in a minute. But the real concern that we see is, and Matt, if you can hand that out for me at any point there, this is about an oily substance, apparently. Because as pointed out earlier in the previous hearing, what this now does is allows possession of hash oil under this provision. Now, some of us have been around a long time in the industry or the dealing with drug trade, and I saw Alex shaking his head, but I remember in the late 80s and early 90s, hash oil was a big deal because it's a much stronger THC product. It's the true derivative from the plant. And the THC levels, I've had one individual tell me that some of the ones in the state that this is modeled out of are upwards of 80% THC in that oil now. So remember, we're talking about a substantially different product than the green leafy material wrapped up and smoked. My concern about the way that this is set up starting in 1612-201 is basically you could possess, so long as you go through this process that we're going to talk about, up to 28 grams now of gel caps or 20 fluid ounces of pure hash oil. And that if you don't have the card, or that you just have this substance and don't have anything to do with this system that's been set up, that's going to be a misdemeanor. And that's in complete contrast to other provisions of the criminal law. So regardless of THC level, we're now going to allow the possession of marijuana. I also point out that this registry card that we spent a great deal of time in HB1 getting something that we all agreed how it would work. We had the agency that regulates it get involved in it. Everybody said this is what it's going to look like. Well, this bill allows not only the Georgia registry card, but any other state's registry card, regardless of what the rules are about getting a registry card. So you could get a registry card in Colorado, and we know there's 60 or 70,000 of those floating around, and walk into Georgia and be exempt under these provisions. The other things that this does before I go into 202 is it attempts, or it does, eliminate weight-based concepts of possession of THC that we established in the HB1. What we did when we did HB1 is we mirrored the definition of marijuana that's weight-based, which has been part of criminal justice reform and other provisions, and that's basically been eliminated here and gone to one level. But what that functionally does is eliminates the concept of trafficking in this substance. So let me now go to, let me move on to the new code section at 1612-203. Well, you got to start at 202. There's a set of definitions in 202 related to buses, school grounds, and what have you. And at 202, at the bottom of that is D. It creates a criminal provision. And basically it says a person who commits a violation of this code section upon conviction shall be guilty of a misdemeanor. Well, you got to step back up and say, look at B and C about what it makes lawful. So it shall be unlawful to smoke or vaporize medical marijuana or gel caps. Okay, that's fine. Or it's unlawful to possess or engage in the use of medical marijuana on that. So we get all that, but what it does is it creates this dynamic with 1612-203. So we've got this basic provision to doing this on school grounds and on school buses, but then 1612-203 says the lawful administration of medical cannabis or gel caps to a child by an individual registered under this shall not be considered a violation. I think I understand what they're trying to do. They're trying to say if you're the parent and you're the guardian and you need to give it to your child at school, that's allowed, but I believe this is broad enough to say that if you're an individual registered, then you can give the substance at school. And I don't think that's the intent, but that's clearly what I believe it allows to happen. Let me move on. I know we're pushed for time. Some other considerations before I move into...
Yes, we are on a clock, but we're not on a restrictive clock. I mean, there's some flexibility. I don't want you to feel like you got to rush, but, if there's a point that needs to be made, I'd rather err on the side of making the point.
Sure.
Thank you.
It's allowing a much larger population to have marijuana in their system and be employed and what have you. We've got to deal with workers' comp, for instance. There's a Drug Dealers Liability Act at 51-1406, which makes all kinds of references back to marijuana. There's the original Controlled Substance Therapeutic Research Program at Title 43, which was the kind of first program in Georgia to look at marijuana, and I believe that's still some contrast there. There's even a tax rate imposed on marijuana in Title 48. I don't know how that works. Title 45 is one of the biggest concerns. That's the drug-free public workforce. And how is all this going to interact with that? Because there's some very strict prohibitions in there. There's a provision in Title 42 related to possession of drugs by inmates that uses a marijuana term. I don't know if we're saying under this that if you got a prescription or you've got a certification for marijuana and you come into the jail, that the jail's got to continue to give you your marijuana. I don't know. And then, of course, there's 161349 and the concept surrounding civil forfeiture that we've just spent several years talking about. It doesn't draw a distinction between this marijuana and regular marijuana. So all of those are issues that I think we need to talk about. Section 6 eliminates the current THC registry. Understand the concept is going to be to transfer the folks that are currently registered for the low THC oil, and I'm going to show you in another place in the code where it brings those folks over, and I'll save my comments till then. So Section 7 starts with the Department of Public Health. It starts off with some definitions, and this is where they're trying to set up this regulated industry. And I'll tell you, after our experience of going to Colorado and seeing and talking firsthand with the individuals that are tasked with regulating their industry, and I get Colorado is much different than what the author is asking to do here, but the same problems exist. You've got a grow that has got to be regulated, because if it's not well regulated, then the substance is going out the back door as fast as it's coming in the front door, or going out the front door. And that's in fact what Colorado has seen over and over, and that's what they're still telling us their problem is out there, is they've got as much grow going on in their state that they can't control as they do that they can. But anyway, this is the attempt for Georgia to create a regulatory scheme to deal with that. So 31(2)(b)(1) starts that out. It's interesting that there's a designated felony definition there that will be used to keep people from participating in the manufacturing process. That designated felony only covers drug offenses. So anybody else with a convicted felon for whatever could not be excluded from this process. So I point that out. There's also the definition of intractable pain. I'm not going to spend a lot of time on it. It got discussed a good bit the other day. This can't treat without the consent of the patient. To us, that is a very broad definition that basically says, I've decided I don't want anything but marijuana. Would you please give me a doctor's note? But we'll move on. HB1 had 8 specific conditions that we spent months and months negotiating and listening to testimony on, and got tweaked at every point and place that this bill had a hearing. Most of those are in the for instance, severe or end stage descriptions of those. All of that's been removed, and now we're looking at 18 different conditions, including some that we've never seen before, like central nervous system or spinal cord induced spasticity. I guess that's back spasms. I will note that the intractable pain would require you to get 2 doctors to give you a note that says, I don't want to be treated by anybody. I don't want to be treated with anything but marijuana, and I got pain. 31(2)(b)(2). That did. Let me see. I believe that stayed the same in the sub. This is a provision that basically says, Social Security and all what have you doesn't have to pay for that. But the other thing that it individual here is accountable under some very strict lobbying rules, money rules, all the things that relate to public officials. That's not true for this department. You look at the amount of lobby and a lot of money that has been spent on this effort to legalize marijuana in this state under whether you call it medical marijuana or what you want to do. That industry, that's not going to stop. That's going to still be involved and it's still going to try to affect what these rules are related to this department. And all of that's going to take place outside the public view. So if that's the policy this General Assembly is looking for, it's fine. But I mean, let's make clear that that's what's going to go on. There's also some attempt to give some guidance and some authority of the department to examine the business affairs, practices, and conditions of the manufacturer. But it's interesting to me that that provision doesn't address the grow facilities at all. And what we've seen from our research is the real problem is the plants. What happens with the plants? How are they controlled from the beginning to the end? And this doesn't give any clear guidance to the department about that. And of course, it closes at the end that any examination that was made, any documents or anything collected during that process shall of course be exempt from open records. 31.2b5 goes forward. It goes on to say, and basically it requires the manufacturers themselves to track the marijuana. Understand this is the true concept of the fox's garden, the hen house. We're telling the people growing marijuana for profit that they need to track and control the plant from beginning to end. So we saw that in Colorado, and we see the problems that they're facing with that. 31.2b6. This places on the department the responsibility to tell the feds the effect that medical marijuana is having for treating qualified conditions. So we're not asking the doctors, we're not even asking the pharmacists, we're going to talk about that in a minute, but we're asking the department to collect data from the manufacturers of marijuana and tell the feds how that's working in a non-clinical environment. I don't completely understand what that accomplishes, but that's the reporting forward that we're discussing. All right, 31.2b7 is the registry and the related parts. Now, this is where I've got a chart that I can provide that basically tells you the difference between HB1 and HB 722. HB1 required a residency in Georgia for 1 year, or a child less than 1 year old born in Georgia. There's no such provision related to that. So everybody, from a policy standpoint, that's a decision you've got to make. But that does eliminate a requirement that was placed in HB1. HB1 required a doctor to issue a certificate that they have a qualifying medical condition. All right. HB 722 does the same thing. However, that's the last substantive involvement that the doctor has to have in this process. Because HB1 required a continued doctor-patient relationship, and that doctor had to be treating that patient for that specific condition. And in fact, that doctor had to issue a quarterly report on the patient that included dosage recommendations for that particular condition and was clear what the doctor's involvement was, who was making the decision about dosage, and what information was being collected about the effective use of that. HB 722 eliminates all that. In fact, it eliminates the required doctor-patient relationship. Now, it does use the term attending physician, but clearly eliminates the original doctor-patient relationship and the quarterly reporting and the doctor making the dosage. Now, what I believe this does is it would allow a doctor to see a patient one time, issue this certificate, and that could be the end of it. It does require continued treatment, but that's vague. I believe that the definition that's in this bill would mean taking your marijuana during that period of time. That could be sufficient to do it. 31B210 talks about designated caregivers. That's pretty consistent with what we're following, what we've seen. 31.2b11 is doctor's instructions to follow the department's rules, but I don't see any penalty for not following the rules. 31.2b12 talks about the 4 distribution facilities as we've been talking about. So we're talking about up to 24 retail locations in the state because each of the 4 distributors can have up to 6 retail locations. There's an attempt in that code section to deal with product quality control. but it shall be the manufacturer's responsibility with a laboratory that they pay. So in other words, the quality control that we're looking for out of the actual grow is being monitored by a laboratory that's being paid by the manufacturer. But they do have to be on the department's approved list. There's the transfer of the low THC oil patients to the registry. So remember now, we had this doctor that had an ongoing patient relationship that has said, you've got a condition that I believe this low THC oil that's defined in code may have some beneficial effect. I'm going to certify that. I'm going to continue this relationship. I'm going to make a quarterly report on how you're progressing. Those individuals now instantly get to move over to this broad, wide-ranging thing. I would be interested in hearing from the doctors that made that original certification under those original conditions and how they feel about their patients now instantly being able to just participate in this hash oil program. Here's one of the other real concerns we see in the way this process is laid out, and it starts in 31.2b13. And this is the concept of dosage. All right, like I said, the doctor's been removed from that. All the doctor says is, you have one of these 18 conditions. Doesn't even have to say, I think marijuana will help you. You have one of these conditions. You now go to the manufacturer, the grower of the marijuana, and they're going to employ a licensed pharmacist. And the pharmacist and the patient are going to decide what kind of dosage of marijuana you need. I don't know where else in the law, and maybe I don't understand pharmaceutical law or process. I don't know where else the doctor does this. Says, I think you need Oxycontin or hydrocodone, but I'm not going to say at what strength or level or quantity or how often you take it. Go see your pharmacist and y'all figure that out. I also point out that I think this is a clear conflict of interest. If this pharmacist is making a living working for this manufacturer, then their primary goal in this is to keep their job working for that manufacturer. We go on even further in 31.2b15 to attempt to deal with who's going to be held harmless and who's not. And I understand the first part of it because it's logical. It says, if a doctor's willing to participate in this registry or issue one of these certificates, that in and of itself is not malpractice, just that mere fact. But it goes on to say that these pharmacists that are licensed, that are working for these manufacturers, that are deciding dosages, shall not be subject to any civil or disciplinary penalties by the Board of Pharmacy when acting in accordance with this chapter. So the rules related to what pharmacists are supposed to do, which I think we're probably already outside the concept of, don't apply after this. So I just point that out. I also like the provision in there that your listing on the registry can't be used basically as part of an application for a search warrant. Now, I get that it shouldn't be probable cause to search somebody just because they're on a registry, but to start telling us that a fact related to that couldn't be used as with other evidence to gain a search warrant or something, I think is a little far-reaching, but that's in the bottom of 31.2b15. 31.2b16, again, like I said, we didn't see this till this morning. I was prepared to do about a 5-minute dissertation on that, but I'll acknowledge that provision has gotten substantially narrowed. But still what remains is 31.2b16a. And we're going to tell no school or landlord that they can refuse individuals that are using marijuana under this substance into their properties or onto their campus. Now, I don't know, but I think that's a pretty significant policy statement when we start telling private owners of property what they can and can't do. Now, I can step out of my role as a prosecutor and step into my role as a landlord and say, I think this is overreaching and telling me what I can and can't do on my private property. But it's there. I make you aware of it. But the testing positive for marijuana by the employees, those provisions have been removed. So 31.2b17, that talks about no physician can own a manufacturer or have a part of that. I think it's interesting to note that that similar prohibition is not there for that pharmacist that's on staff that's making the decisions and involving themselves in this process. They can own or be a part of this manufacturing. So I guess a pharmacist could be one of the manufacturers that get licensed under this and then turn around and do the dosage with the patient under this concept. 31 2B18 talks about the fees. Section 8 is it removes. Let me make sure. Yeah, apparently right now there's a warning that goes out about certain controlled substances that are dangerous and habit forming, and apparently we've decided from a policy standpoint that marijuana is not habit forming. Now, I've been to every one of these hearings in the last 3 years that we've been dealing with this, and I'm not certain that I've heard that hash oil could not be habit forming, but we're going to remove that from pharmaceutical proceedings. The piece that I handed out just now that I had Matt hand around is specifically about vaporizing and hash oil. I want you to understand, when everybody keeps saying we're not legalizing marijuana because we're not going to let everybody have the green leafy material, that's becoming an archaic way of consuming marijuana. This is becoming the new way of consuming marijuana, both legally and in some states. I mean, some states legally and most places illegally. Is through this vaporizing and from this liquid. And there's a lot of reasons for that. First of all, it doesn't smell like marijuana does, and you can consume it in places where people don't know that's what you're doing. So let's don't be fooled by the fact that this can't be abused, because this is the way our children are learning to abuse this product now, and I'll show you that report for that. Section 9 removes the healthcare providers from liability. That was added in HB1, and it's just broadened for this new concept. And then Section 10 is the effective dates, and I think you heard the explanation for those the other day about the different ways the current registry and what have you would stay in effect for the next year until the new registry goes into effect. So those are some of the highlights of what we see in this bill, some concerns about it, and it's also why the prosecutors in this state are opposed to this bill and this concept for this broad concept of distribution of marijuana with a doctor's note. So,
thank you, Mr. Bass. We'll take some brief, the keyword being brief, Q&A, if any, doesn't have to be, to Mr. Spahos. Any members have questions for Mr. Spahos? Again, this is hearing. There will be no vote today. Mr. Setzler.
We're going to disappoint the chairman with no questions.
I was that close.
Again, the chairman, there's 8 or 10 questions I want to ask, but I will just ask a few. The jail cap definition online. $125, as I read it.
Discussing, or that wax product that's extracted from the plant that's a super high THC level, is once you can get it in the jail cap and close it, then it's covered.
Right.
And we do know that it's very common to take jail caps apart and then inhale the substance that's contained therein in a much different manner than which the jail cap was intended.
Okay. Sure. One further question just about that section 4. Certainly have an interest in, perhaps not now, but discussing the implications of other state cards being brought in and being able to be used, but I won't go there. What I do want to ask a question about is the THC content. You know, we talk about 28 grams of hash oil or something that's saying 80% concentration of THC. Help me understand the line of misdemeanor versus felony today is 28 grams. But would be understood as being a leafy substance, as it were.
Right, an ounce of green leafy. It's about
right.
That much of a bag of marijuana.
Right, and as your colleague Danny Porter so artfully said last year, in the Cheech and Chong days, that was 0.7% THC. It's increased. You call it 4% THC. for the same 28 grams, do you read this to say that if you've got THC oil, it's 80%, and you have a gram of it, versus leafy substance that's 4%, what this is doing is it's taking the threshold of THC hallucinogen and increasing it 20 times, just measure that 4% number I'm using. Just that's around
Amount of THC.
It's an order of magnitude plus of the allowable hallucinogen that you can possess and still be either legal under this bill, or even if you haven't followed the process, you're still a misdemeanor land, you're not.
That's correct.
No further questions. Thank you, Mr. Spanos. Again, we're hearing only on 722. What we'll do is we'll take 5 to allow folks who are here on 722 to clear, and in 5 minutes we'll begin consideration of House Bill 941.
What do you want, boy? Oh, I love you. Yes, I do. You want a bone to chew on? You want something to chew on? Is that what you want?